In this video, I will explain why your operating agreement won't save you in court, and by the end of this video, you will learn the 3 crucial mistakes that make operating agreements fail and what you need to do right now to actually protect your business. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've seen countless business owners lose everything because they believed a piece of paper would save them. It won't. And let me explain why. Imagine you've signed an operating agreement, you think you're protected. Then a lawsuit hits, and suddenly that document you paid a lawyer to draft, it's worthless. This happens more often than you think, and I'm about to show you why. Most business owners treat their operating agreement like a bulletproof vest. They think that just having one means they're safe, but here's the truth. An operating agreement is only as good as how you follow it. Let me tell you about a client I'll call Marcus. Marcus owned a successful tech company with 2 partners. They had a beautiful operating agreement, 50 pages long, drafted by an expensive law firm. It covered everything, or so they thought. When disputes arose, Marcus stopped following the agreement. He made decisions without consulting his partners. He transferred company funds without proper authorization. He ignored the voting procedures outlined in the document. 2 years later, his partner sued him. Marcus pulled out the operating agreement in court. He pointed to provisions that protected him. The judge looked at the evidence. Then the judge said something that changed everything. The judge said, "This agreement means nothing if you don't follow it." Marcus lost. He lost his stake in the company. He lost millions of dollars. And that operating agreement, it became evidence against him, not for him. Now, here's what most people don't understand. An operating agreement protects the structure of your business. It doesn't protect you personally. Not if you mess up. Courts can pierce the corporate veil. This means they ignore your LLC protection. They go after your personal assets, your house, your savings, everything. When does this happen? Well, when you treat your business like your personal piggy bank. When you mix personal and business expenses, when you don't maintain proper records, and when you undercapitalize your company. Your operating agreement won't stop this, and it can't, because the courts look at your actions, not your documents. I had a client who ran a construction company. His operating agreement was perfect, but he paid his personal mortgage from the business account. He bought groceries with a company card. He never held formal meetings. A contractor sued his company, and the contractor's lawyer proved commingling of funds. The judge pierced the veil, and my client's personal assets were on the table. The operating agreement sat there, completely useless. Now, if this is making you nervous, good. You should be paying attention. Do me a favor right now and hit that like button and subscribe to this channel, because what I'm about to tell you next could save your business. Here's another way operating agreements fail. They become outdated. Your business changes, your partnership changes, but your operating agreement stays the same. Most operating agreements have amendment procedures. You need unanimous consent, or you need a supermajority vote, but nobody follows these procedures. They shake hands, they make verbal agreements, and they move forward. Then a dispute happens. Someone pulls out the original operating agreement, and suddenly that handshake deal you made 3 years ago, it doesn't exist. Well, not legally. I see this constantly with buy-sell provisions. Partners agree to change how they'll handle someone leaving the company. They discuss it over lunch. Everyone nods. Nobody documents it properly. Nobody files an amendment. Years later, a partner wants out. The remaining partners try to enforce the lunch agreement. The departing partner says no. He points to the original operating agreement. The court sides with him because the amendment was never properly documented. Now, the operating agreement became a trap, not a protection. Most operating agreements are templates. Someone downs a form online, or a lawyer uses their standard document. They fill in the blanks, they sign it, done. This is dangerous because generic provisions don't protect you in specific situations. Every business is different. Your operating agreement should reflect your actual business, your actual relationship, and your actual risks. But most don't. They have provisions that don't make sense. They have clauses that conflict with each other. They have terms that can't be enforced in your state. Florida law is different from California law. What works in New York might fail in Texas. A boilerplate agreement doesn't account for this. I reviewed an operating agreement last month. It was for a Florida LLC, but half the provisions referenced Delaware law. The dispute resolution required arbitration in New York. The court would have thrown out half the agreement. The owners had no idea. All right, so what's the solution? How do you actually protect yourself? Well, first, follow your operating agreement, every single provision, every time, no exceptions. If it says you need to hold quarterly meetings, hold them. If it requires written consent for major decisions, get written consent. Document everything. Second, keep your business and personal finances completely separate. Never mix them. Not even once. Not even for a quick transfer that you'll fix later. Maintain meticulous records. Third, review and update your operating agreement regularly, at least once a year. When your business changes, your agreement should change too, and follow the proper amendment procedures. And fourth, customize your agreement to your actual business. Work with a lawyer who understands your industry, your state, your specific situation. Don't use a template and just hope for the best. And fifth, understand that an operating agreement is just one tool, not the only tool. You need proper insurance. You need good accounting practices. You need asset protection strategies that go beyond just one document. Look, an operating agreement is important. I'm not saying it's worthless. I'm saying it's not magic. It won't save you if you don't do everything else right. Too many business owners learn this lesson in court when it's too late, when they're losing everything. Don't be one of them. If you found this valuable, smash that like button and subscribe to this channel for more content that actually protects your business. Not just theory, real advice you can use today. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.